the Wednesday meeting. It's a little after 9. Remember, we're on live stream, so if you ask a question or if you're presenting, please speak into a microphone because they tell me people listening in can't hear you otherwise. We're going to jump around a little bit this morning on the agenda. We're going to ask our Vice Chairman, Senator Sparks, if he'll kick us off with Senate Bill 2613.
Thank you, Mr. Chairman. 2613 is a bill that was brought to us by the Police Chiefs Association as well as the university and college chiefs. There's a training mechanism that our college chiefs have not been participative in over the years that this would require that training. Just a second, I'll get to the bill so I can tell you exactly where we're looking. As you see, it adds Public College, University, and the Pearl River Water Valley Supply District that the chief of police is required annually to complete 20 hours of executive level continuing education. And if they're a new chief, 40 hours of executive level continuing education. Our municipal chiefs were already doing this. Maybe a lot of our college chiefs were, but it was not required. There's a letter of support from the colleges and community colleges that they do support this legislation, this requirement. In addition to that, this training would be reimbursed just as the municipal training would be reimbursed. And I've had a calculation provided to me that additional training for the chiefs, and then the second part deals with training for officers, would be less than $30,000, and that would come through the Department of Public Safety. I think the Association of Police Chiefs provides a lot of this training already as well. That's a brief explanation of the bill, and I would yield to any questions.
Questions, Senator Barnett.
Thank you, Mr. Chairman. Senator Sparks, just why is the Pearl River Valley Water Supply District included in this?
That is how the chiefs brought it to us. There's a chief of police apparently with the Pearl River Valley Water Supply District, if that's the way it's listed. I don't know if Donna, there you are. Okay. Is that the case?
That's correct.
Thank you.
Thank you.
Question. Any other questions for Vice Chairman Sparks? Not for a motion? Motion is title sufficient to pass. All in favor say aye.
Aye.
Any opposed, nay. The ayes have it. All right, and right beneath that, you have a committee substitute, which is a loose sheet that should have been handed out with your packet on 2614. Committee substitute, Senator Sparks.
Thank you, Mr. Chairman. 2614 addresses appeal process in the criminal system. This is an issue where the Attorney General defends all of these appeals. And for those maybe who practice law or who don't practice law, or a refresher for everybody, if you have a trial or enter a plea, you can appeal out of the circuit court. We're talking about felonies. You appeal generally to the state Supreme Court. The state Supreme Court may assign that case to our Court of Appeals. We created a Court of Appeals several years ago to actually facilitate quicker access on these appeals, or the Supreme Court can take it up themselves. And if you are not happy with that decision, you can appeal that to the United States Supreme Court. Once you've exhausted all your direct appeals, there is something that is referred to as post-conviction relief, and that's what this bill deals with. We start with 9939.5. This is giving the grounds that after you have exhausted all your prior appeals, that you can request post-conviction relief on issues that are on line 22A through J. Those are the items that are typically that come into play when you're looking for an out-of-time appeal or post-conviction relief. What you also see is that there are exceptions to this rule because you have 3 years to make those claims, generally 1 year in a capital case, but you then have exceptions that if that time has told, that 3 years has told, there are exceptions, one of which is an intervening decision of the United States or Mississippi Supreme Court, which would potentially have adversely affect the outcome of the conviction, or newly discovered evidence. So the first thing that happens on line 69 is those exceptions will toll the statute of limitations for 1 year from the time that mandate was issued on the decision, or the newly discovered evidence could have been discovered through the exercise of due diligence. This simply puts a timeline on when you can use that exception that doesn't leave it open-ended. When you get to line 95, the ineffective assistance or incompetence of counsel during this post-conviction proceeding is not a ground for relief in a proceeding arising under this article. The reason this legislation to a great degree comes to us on this point is that in around 2013, the Supreme Court created this kind of additional ground, not statutory, but the court created it, and have basically overruled themselves in 2024, so in the RONK decision, RONK, and have asked to a great degree that we codify that this is not a grounds. What this means is you moved through the process, you had counsel along the way, then you file your post-conviction relief, which again is after all the direct appeals are over. Then you follow that up when it's not a favorable outcome and say that counsel was ineffective. There is no such grounds in the federal post-conviction relief, to my understanding, and this would simply marry that up to that. In the next two sections, it is the same information repeated in the other codes. If you look at 167, again, the intervening decision exception, as well as the evidentiary newly discovered exception, has a 1-year statute of limitations to act on it. 180, you see the same language on ineffective or incompetence of counsel is not a ground, and therefore it's also not an exception. And then the same thing again in 99, 39, 23. So it does those two things in all three statutes. Mr. Chairman, I would yield to any questions.
Good explanation. All right, any questions for Senator Sparks? Anyone? All right, if not, for motion? Motion is Title 52 pass committee substitute. All in favor say aye.
Aye.
Any opposed, nay. The ayes have it. Thank you. Good explanation. All right, Senator Rhodes, Senate Bill 2609. If you'll grab one of those microphones, please, sir, and tell us about the bill.
Thank you, Mr. Chairman. Senate Bill, if you'll direct your attention to Senate Bill 2609.
Mr. Chairman, is this the freshman's first bill that he's presenting?
It's
Oh,
the
boy.
first one in this committee.
Whoa! Motion to table.
Please proceed.
All right, so if you would avoid the short title, it's a little bit confusing. It says that this bill, effectively, all it will do is raise the minimum fine if you drive uninsured from $100 to $250. And then on line 88 through 95, says in addition to any other penalties imposed by law, a motor vehicle operated on the roadways of this state where the owner of the operator of a motor vehicle fails to have mandatory liability insurance required by this section, and mandatory, if it's involved in an accident, that it will be impounded until they can prove that they have obtained insurance. It's estimated that 29% of Mississippians drive uninsured. We are #1 in the country on uninsured motorists, and I think it's puts undue burden on the law-abiding taxpayers that have insurance. And I don't really know. It's a pretty simple bill. That's, if you got any questions, I don't know if I can answer them.
All right,
Pretty simple.
a good explanation. Questions for Senator Rhodes? Any questions? Senator Sparks?
Thank you, Mr. Chairman. If the car is impounded, whose duty is it to hold the car, and will the person be charged for the days the car is in an impound lot?
Who will?
If the car is impounded, who will take custody of the car? Where will it go? And will the person's car who has been detained until they provide insurance then be charged a daily rate for the storage of said vehicle until they get insurance?
Yes, it says that they would be, the responsibilities of any fees associated with it would be due to the owner or
Thank you.
operator.
Thank you.
Okay, other questions? If not, for a motion? Motion's Title 52 pass. All in favor say aye. Any opposed, nay? All right, the chair is in doubt. Let's have a show of hands. If you're in favor of 2609, please raise your hand. And if you're opposed to the bill? All right, the chair is no longer in doubt. The motion does not succeed. Thank you for presenting the bill. We appreciate you. All right, Senator McClendon on Senate Bill 2438.
Thank you, Mr. Chairman. Thank you for committee for letting me sit through. Y'all don't mind dumbing y'allself down just a little bit. This is a real simple bill. Basically, what it says is if a person willfully enrolls a child in a school district, knowingly that they don't live in that school district, they will be charged with a misdemeanor. Child will be suspended, and they will be subject to $500 fine and up to 30 days in jail.
All right, and tell us the situation under which these things come about. I know in DeSoto County, you tell me it's a major problem. So what are y'all experiencing in DeSoto County that brings you to bring this before us?
We've had such a mass problem with that. The supervisors did an ordinance to this effect.
So you're just carrying out what your local supervisors have asked you to do in this situation
Absolutely.
because of the influx of children from out of state?
Out of state, out of county. We have bordered by 3 counties. And being the #1 school district, a lot of people want to go there.
Right.
The issue at hand is that over the years, we've had 3 different bonds. And with those bonds, we've built schools. We also pay an extra ad valorem tax that goes to those schools. So they're basically stealing from DeSoto County school or DeSoto County taxpayers.
And what are the current penalties? This bill, before it's put on the books, if you're caught doing this, you bring your child across county district lines to enroll them in DeSoto County and when you don't live there, what are the current penalties?
Expulsion,
You just get expelled, the child does.
yes.
All right, and so you want to put some teeth into the law to make it less appealing to do so.
Absolutely.
All right, questions, Senator England?
Senator McClendon, I appreciate what you're doing here. As I understand it, you have parents that are wanting to send their kids to schools in your district because they're the #1 schools. Is that what you said?
Absolutely.
Okay.
Safe.
And safe. So we've got parents that are trying to send their kids to safe and better schools,
Yes, sir.
and we want to punish them for that in this bill?
No, sir, we're only going to punish them if they won't move there. They have all the opportunity to move there, buy a house, rent an apartment. Whatever they might do to make that place domicile.
Why aren't they moving there?
You'll have to ask them that.
Do you think it might be because they maybe can't afford to move into DeSoto County?
You'll have to ask them that.
Okay.
Should the taxpayers of DeSoto County flip the bill for every child in the world to be able to come to DeSoto County schools?
Right. So I understand that that's the issue. It's a money issue. I wonder if this situation might be better served, and I know you sit on the education committee as well, if we were to allow more school choice in this state and allow tax dollars to follow these students that are coming to your schools, because I just have a problem with punishing parents with young children because they
welcome
want to
anyone.
give them a better opportunity. Would you be willing to look at at some legislation possibly? Because look, I don't support this bill as written because I
So
don't like that.
You're in favor of stealing from taxpayers?
I'm in favor of figuring out a better solution to the problem. I don't think that your bill
We're
is the
gonna let
best
every
solution.
child in Mississippi come to DeSoto County schools?
Apparently you want them to move there, which is great. I don't think that's the issue. Look, you're looking at it from one side of the problem, Senator McClendon. The other side of the problem are parents who want the best opportunity for their kids. I think there might be a better solution out there. Other states around us are looking at school choice. They're looking at ways to allow tax dollars to follow the students into the schools, because this is an issue. You have students coming in and they're not paying taxes, and look, good schools cost money, right? We all know that. I wonder if you
Believe
would,
me, I know, because I've been paying it for 30 years.
if this bill doesn't pass, would you be open to looking at what other states do to allow for tax dollars to follow the students and the parents that are trying to find better education for their kids?
So that includes Tennessee residents who don't pay Mississippi tax to come down
Senator Clinton,
and join our school district, or
Look, we-
Arkansas, come over and
we can certainly look at that, some sort of reciprocating legislation, if those states would be open to doing the same thing. Because the problem as I see it is that parents want their kids to be educated in the best way that they can.
Sure.
And I just,
they can homeschool.
I don't know that, and I know and understand that you're bringing this bill because your supervisors have asked for it. I just don't know
I've
that.
got taxpayers asking for it.
Well, and I understand that. I don't know that the best solution is to criminalize the parents for this act. And I know that this bill does that, and that's why I can't support it. But I would just ask you
So
if
if
you
the
would
kid's
be,
expelled, is that penalizing the child?
well, it certainly is, yes. So
So
does
we
this
do that
bill-
every day.
Well, we do suspend children every day for actions that they do at school, presumably. So let me ask you this. This bill would require the students to be expelled? Does this bill require the students to be expelled for an action of the child?
The child is part of the action. Yes, he's showing up to a school that he doesn't belong in, that he's not living in.
I disagree with you, Senator McClendon. I will yield to others that may have
This has
questions.
nothing to
but-
do with school choice. And yet it has everything. You have a choice to go and buy a house or rent a house in the school district you want to go to.
I understand that.
And there, we have rental houses all over DeSoto County.
I think as you and I sit
We also
here-
have property you can buy all over DeSoto County.
Yeah, thank you. Thank you, Mr. Chairman. Thank you, Senator McClendon.
Recognize for question.
Thank you, Mr. Chairman. Senator McClendon, my question is similar to Senator England's question. And you kind of got into it when you said that, yes, we suspend students every day. And yes, school districts do this, but that's an action of that child. And in this bill, you're saying that we're going to punish the child again for an action that they may have known anything about. So if you have a pre-K or a first grader that their parent has enrolled in that has enrolled them in a school district, so are we gonna suspend this first grader for an action of their parents? And even if it's a 9th or 10th grader or high schooler that needs to be in school somewhere, and this is where their parents chose to put them in school at, are we gonna throw these children, are we gonna suspend these children again for an action of the parent? I mean, why are we punishing innocent kids for an action of the parent? Even if we just talk about elementary school children, and maybe these parents can't afford to live in DeSoto County. Maybe the rent is too high. Maybe the purchase of homes are too high. There may be a number of factors why they can't. So I agree with Senator England. I don't think that this should be an action where we should punish a first grader for the action of the parent that's trying to get them into a better education system.
Well, right now, we've got a student at Hernando High School that's being punished playing on the baseball team. He wanted to play on a better baseball team. So he came out of district. So should he be suspended?
All right, Senator Sparks.
Thank you, Mr. Chairman. In section 1, and I realize you're not trying to change section 1, but on line 20, it states that no pupil shall be permanently enrolled in a public school in the state of Mississippi that was formerly enrolled in another public or private school within the state until the cumulative record of the pupil shall have been received. Is there a process when somebody comes to school in DeSoto County that they have to fill out paperwork?
There is.
and they have to sign that. I'm assuming a parent or legal guardian fills that out or assists them in filling that out.
Yes, sir, there is. And the problem is that you have multiple families, put the same address down.
It-
One family may have the water bill, but you got 5 families living in the home.
Have you consulted with the local
Oh, there's-
attorney, for DeSoto County to see if there is some language that could be put into your enrollment documentation that creates a civil cause of action, for defrauding the school district? That, I think that may be an option, may not be. I don't work in school rules, but, the criminalization part is pretty tough. I want to ask you a question about the new language. In 72, of course, it's criminal conviction. When the Department of Education counts students in DeSoto County, do they count the one that you're aggrieved with, that you don't think should be there properly? Does DE count those students?
I'll have to find that out. I do not know. that.
You think they come through, know that that person is not properly in the school, and say, don't count Johnny, but then doesn't do anything?
I think the problem arises when you have multiple families using one address, but they're not living at that.
Well, I'm talking about the students. They come into this room. If I wanted to count the number of senators in here in this room, I just count them. But then I could also say who's on the committee, who's not on the committee. My point is, if DeSoto County's counting these students, they're receiving money based on the MAEP formula. So that's improperly going to DeSoto County. If you're going to criminalize the parent putting them in there, I understand the frustration, but that's the concern we run into, is all of a sudden now the MAEP formula has erroneously sent money to DeSoto County.
I'm sure
based
it's
on
sent
what you're
back.
saying.
It's probably sent back if that's the case.
Well, not if they're there. You know, I don't think that's the way it works. The second thing,
Well, I think
Last-
once they're expelled, I believe it's probably sent back, but I'll have to verify that for you.
and then the last thing in subsection B, there's a requirement for the department, school district, or any school employee, so anybody that works there, to notify law enforcement. So you've created a duty. What's the penalty for failure to notify law enforcement by a school employee?
Well, I would assume, and we don't assume in here, that that would be up to the school board and the school superintendent.
So the legislation creates a duty, but is silent to the punishment.
We can add an amendment if you like.
Well, I'm just saying that that could be anywhere where they're not criminally liable per the statute, but you're telling me that could be anything from nothing to the school reprimands, disciplines, or terminates?
I'm not saying that at all. I'm saying we can add an amendment.
All right, thank you.
All right, any other questions? All right, if not, for a motion?
So if I could, Mr. Chairman,
Okay, I'm sorry, we got a question. Senator Simmons has a question.
Yeah, I actually have one question and then I have a motion, Mr. Chairman. So Senator McLean, we are basically criminalizing the act of the actual parent, the legal guardian, or the custodian of the child. Correct?
yes, sir.
And this is for DeSoto County,
No, sir, it's for the state of Mississippi.
say Mississippi. But you're saying the reason why you actually sponsoring this bill is because of the problem that you are experiencing in DeSoto County.
Where I live, yes, sir.
And the part of it that says $500 fine or by imprisonment for not more than 30 days, are you sure that your DeSoto County judges will really put people in jail?
Well, that will be up to the judges, sir, just similar to, we had a little judge discussion yesterday.
And so, Mr. Chairman, at the appropriate time, I do have a motion.
Recognize.
My motion is I move the table.
Motion, would you like to speak to the motion?
Could I still speak on the bill?
Would you like to speak to your motion first?
Yeah, I mean, in light of the debate, certainly the concerns that were expressed by Senator England, also Senator Barnett, and also Senator Sparks, if the real issue is school choice, then certainly we'll have an opportunity to discuss that through this process and look at policy as it relates to that. But as proposed, to criminalize the parent, the legal guardian, or the custodian, does not seem to be the solution to the actual problem that's expressed by Senator McClendon. So there are certain other opportunities to address his concerns. So this bill in its current form, that's the reason why I make the motion to table.
Mr. McClendon, you're recognized to speak against the motion.
Yes, sir. What we're doing is we're adding undue burden on our teachers. We're adding undue burden on our taxpayers, our bus drivers, because we get kids that'll be dropped off at bus stations. Now this has not just been, we decided to assess ourselves last week, last month, last year, last decade. This has been going on, that we've been paying extra for DeSoto County schools for decades. Not just people that go to school, older people that own houses, businesses, cars. Anybody that pays any ad valorem tax in DeSoto County pays extra for the 3 bond issues we had. How do we make those people whole through the years? Starting all through the years. How are they made whole? Do we let everybody? So are we a sanctuary district, school district? Is that what we are? Is that what we're saying? DeSoto County School District is a sanctuary school district. Senator England, you want everybody in the state to come up there. We are. We're going to bus them all up. We're going to train them. We're going to put them on an airplane. We're going to have a tent city. What do y'all want to do?
All right. Back to the author, would you like to respond? All right, you've heard the motion, which is to table. All in favor say aye. Aye. Any opposed, nay? Nay. The ayes have it. All right. Thank you so much.
Thank y'all for inviting me.
All right. Let's see. Now Senator England, 2186. You're up.
Flip to that bill, Mr. Chairman. Thank you for calling this up and for allowing the opportunity.
2186.
Yes, 2186. So this, I guess refreshingly, this is a very simple bill. If you'll look at lines 21 to 22, that the language that was stricken there allowed for police departments to use the monies for the sale of seized weapons to go towards the purchase of bulletproof vests. We have since allowed for funding for that by other mechanisms. So this just simply takes that limitation out and allows the police department to purchase equipment with those monies. And that's what the bill does.
The reason for that, in part, as I understand it, is that the other stated purpose has largely been fulfilled, and they don't need all those monies for that specific purpose. So now you have other needs for law enforcement that these monies could be used to purchase. Is that right?
That's absolutely correct.
I saw a hand, I think. Senator Wiggins, was it you? Somebody? Okay. Anybody else for question? Oh, Senator.
Thank you, Mr. Chairman. Senator England, are there any parameters are this based on their normal eligible purchases? Is what they would be basically be looking at would be the parameters. There's nothing outside of their normal purchases. Am I correct?
So this just mentions equipment. So there aren't any parameters. And if equipment is defined in any other code, I'm not aware of it. But this would allow for the department to purchase equipment with the money. So I guess to answer your question, I'm not aware of any parameters around that language.
Donna, do you have any insight into that?
Oh, excuse me. No, Mr. Chairman, I do not. I know that they talk about purchasing that with vehicles and things like that. But to answer your question, Senator, I don't know of anything else outside of that, other than law enforcement equipment.
Senator DeBar for a question, or Senator Norwood, are you finished with your questioning?
Right. I mean, that gave me some insight. I mean, vehicles are normal purchases and, things like that.
Yes, sir.
Just want to make sure.
Okay, Senator DeBar.
Thank you, Mr. Chairman.
Senator England, good bill. I don't want to do any damage to it, but the money that's from the sale of the weapon, does that go to the sheriff or does it go to the county general fund specifically for the purpose of buying this equipment, which I think is needed? Don't get me wrong. I'm just curious where the money goes on the sale.
Yeah, and I think that's a great question. I would ask the chairman to allow Ms. Eccles to maybe speak to that.
Yes, ma'am, you're recognized.
So I can't speak to sheriffs per se, but I can tell you that for police chiefs, the money goes to the city where it was confiscated. And I'm assuming it would be the same for the sheriffs.
And I'm not sure what the statute says on that anyways, elsewhere. It may say something elsewhere. I don't know, but that's something that you could look at before the bill comes up before the floor.
Absolutely. I will certainly get you an answer. Yes, we'll get you an answer before this bill would come on the floor.
Great question. All right, any others? I won't leave anybody out. All right, Senator England for a motion.
Well, and I would just like to address one more question. My colleague, Senator Barnett, leaned over and asked about illegal weapons, and which I'm assuming would be weapons that maybe have the serial number marked off of them or automatic weapons. And I believe we have provisions in other statutes, and I will check on that before it comes on the floor as well, that those weapons are likely destroyed. It's my understanding, but I will get you an answer on that as well, Senator Barnett. Before I make my motion, I wanted to address that. So my motion is title sufficient do pass.
Oh, Senator Sparks, I'm sorry.
Yes, absolutely.
Another question.
Based on that, what do we do to clean serial number of a crime, of a gun that's been seized that we resell to the public? Is there like I don't have to know that right now.
Right.
I would like to know, what do we do? Otherwise, I go buy a gun somewhere and ultimately it's been used in a crime.
That's right.
Okay, thank
Yeah,
you.
no, I will certainly get an answer for you on that as well before we bring the bill on the floor.
Good observation. All right, anybody else? Senator England, you recognize for a motion?
Yeah, motion is title sufficient do pass.
All in favor of the motion, say aye.
Aye.
Any opposed, nay? The ayes do have it. All right, last bill we're probably gonna take up this morning is 2626. Senator Hickman, you are recognized.
Thank you, Mr. Chairman. So what this bill does in the most simple form is it would take away the prohibition of a nonviolent felon from having access to a firearm and other weapons. As you guys know, any felon in this state, in most states, and in the federal government, it allows them to, they're restricted from having a firearm ever, no matter what the felony is. And so this would restrict our law to only violent felons as defined in our statute or as a judge defines in their sentencing. And I'll just give you a little backstory where this came from, how I got involved in a bill such as this. I had a client that I was representing. He had 2 drug charges in the 90s, got out in 1996. He was employed every single day until 2023 when he was ultimately sentenced. He was actually using his white vehicle. Those kind of facts don't matter, but at the end of the day, he was sentenced to 10 years in prison for possessing a firearm after having had a. So I got into this, did some deep dives, and come to find out there's a lot of cases right now, and we think the Supreme Court is going to determine this on the federal side, that basically say that it was not the original intent of the Second Amendment for nonviolent offenders to be prohibited from having their handguns. And one of the chief proponents of bills such as this, and she quoted this as the most influential opinion when she was speaking before the judiciary, as the most influential opinion she had written, and that's Justice Barrett, Supreme Court Justice Barrett, when she was wrote an opinion when she was on the Seventh Circuit. And in that opinion, she stated, history consistent with common sense. It demonstrates that the legislatures have the power to prohibit dangerous people from possessing guns, but the power extends only to people who are dangerous. Founding era legislators did not strip felons of their right to bear arms simply because of their status of a felon, nor have the parties introduced any evidence that the founding era legislators imposed virtue-based restrictions on the right. Such restrictions applied to civil rights like voting and jury service, not to individuals' right to possess a gun. And so it wasn't until 1791 that they started restricting felons. So this law, I believe, would bring our state into compliance with the true intent of the Second Amendment. And I'll take any questions.
This is a pro-Second Amendment bill.
Yes.
There. All right, Senator Wiggins.
Thank you, Senator Hickman. My only question, Isn't there a procedure currently to restore a person's rights to own a gun, and like the person you highlighted, my recollection serves me, there's a procedure by that way that person could go and restore the right.
Absolutely, but I think the Second Amendment, yeah, it's there, but I think that the Second Amendment would speak to not taking away the right rather than someone having to have their right restored. And I think this leaves open, and that stays there because a violent offender could ultimately, who's convicted on a violent felony, could ultimately petition. But I think it's better to have a right never be taken away than to have to restore a right, particularly an enumerated right in the Constitution.
Senator Hill? Question?
Thank you, Mr. Chairman. When we were discussing this Miller case and some of the other cases and bills that we've discussed, the DAs talked about, you know, how many times that they use plea bargain to go ahead and sentence and not wind up going to court. My concern is that when you go back and look at many cases, what somebody was actually pled to or sentenced to, might not have been a violent crime that they committed, but, you know, the violent offenses might have been dropped for a plea bargain. So that's my concern, is what somebody actually was indicted for or was sentenced for, many times is not the extent of their crime. So I don't think that we can actually know, because of a sentence, what is in the background of an individual, as far as maybe something violent that they didn't plead to. So that would be my concern.
Yeah, the bill speaks to that. If you'll look at line 24, not line 24, line 28, it allows for felonies listed in 97.321, but it also, a judge could designate a felony as violent under 97.322. And so if they plead to one thing and the judge can designate that as violent if they know the facts and all of that in there. So it still leave open room for that.
But I guess that depends on the judge, if I may follow up, because, you know, some judges might, but many may not.
Senator DeBar?
Thank you, Mr. Chairman. Senator, so this is a discretionary function for the judge. They don't have to grant the rights back to them, the gun rights back to them?
So if they're a nonviolent offense, it's an automatic granting of the right. But now this just leaves open, even in our violent crime statute, it leaves open for, if a judge sees something as a violent act that's not designated on their list, they can designate that as violent. And this just follows 97.32. But if it's a nonviolent offense, once they have completed all of their time, their probation, paid back all their restitution, done everything they're supposed to do, it's an automatic restoration.
I mean, if someone's on paper doing the probation parole, they're more than likely going to behave better than they would if they're not on paper. Would you agree with that?
Absolutely.
So I'm saying is, should we at least put a timeline there or a time frame in there saying you've got 3 years the day you come off paper, or 5 years or something like that?
And if you want to work on that, I do not mind. I'm not married to this language, but I do think this is something that we absolutely need to do. And if we want to put a time restriction, I'm open to that. I'm not against that at all.
My experience, judges, I'm not going to speak for St. England or Wiggins, but my area, they wanted to see some time. They granted the certificate of rehab, you know, some time off of paper to check their behavior, to make sure that they were doing good and behaving like good citizens would be. Is that something you could look at?
That's something I can look at. The only thing I would say is, and again, I'm very open to putting a time restriction on there. Maybe we can put some language if they, you know, don't offend again this time. I would still like it to remain automatic, that they didn't have to go back. Like after this period of time, if they don't have another felony or whatever, it's an automatic right restoration.
I would like to see, and maybe we can work on it, and maybe the committee wants to take it up now, you know, at least be 3 years off of paper before.
I'm fine with that amendment if you make it.
Or something to that effect. Is that something, if I can make that amendment, Mr. Chairman? So I'd like to, Ethan, do a conceptual amendment, Mr. Chairman, saying that the right is granted 3 years from the date that the offender or the person comes off of paper, and you can word it how you think is appropriate, Ethan. That's my amendment, Mr. Chairman.
All right, any questions for the author of the amendment? Not, all in favor of the amendment, say aye.
Aye.
Opposed, nay. The ayes have it. I think Senator Barnett had a question.
Yes, thank you, Mr. Chairman. Senator Hickman, would you agree that now in Mississippi and other states, that we are working towards the legalization of marijuana,
I can't,
whether it be medical or recreational use?
well now, for medical purpose, I wouldn't say that that's legalizing marijuana, but I would say that, marijuana is becoming, more common.
My reason for that question is that wouldn't you also admit that maybe in the seventies or eighties, there was individuals who was convicted of a marijuana charge, which carried a felony, but have been since released and now, well, and have been productive individuals and can't even take their grandsons out on a Saturday hunting, trip or anything because of them not being able to possess a firearm?
Senator Barnett, that's exactly the example, you know, that I was kind of giving, and I didn't want to go into like the factual details, but I appreciate the question. My client actually bought a restaurant, and it was kind of in a bad part of Jackson, he and his wife. And the gun that he was found in possession of actually belonged to his wife, the vehicle was registered to his wife, but his truck was blocked in, and he grabbed her vehicle, and when he was stopped, he looked in the console to get the insurance, and he literally said, "Oh my God," like on the body cam, there's a gun here, alerted the police officer. He didn't even know the gun was there, and so it keeps you from being able to protect your home and your family and all those kind of things. And so I absolutely agree with that notion.
Thank you. Senator Super?
Thank you, Mr. Chairman. I have a couple questions. How many people would this affect if this bill went into law? You have any kind of number of how many? Because I mean, it's gonna be retroactive to all these, people that have some nonviolent crimes.
I have asked for those numbers, and so I should have them before I get to the floor, but I don't have the exact numbers yet.
And my other question is about habitual offenders. I mean, I do a lot of criminal defense work, and I mean, I've had cases where people's been convicted 7, 8 times, and they're all nonviolent, but they just kind of keep skirting by. Should there be any kind of provision, maybe if we have just people that are continuing to break the law, like commercial burglary, I think is a nonviolent crime, but that's still, to me, a serious offense.
Senator Super, I agree with the sentiments of that, but I think we go back to looking at the original intent of the Second Amendment. And I think if people are not dangerous, as Supreme Court Justice Barrett said, if the individuals are not dangerous and they're not causing a harm to themselves or society, even though they continue to do these nonviolent offenses, I think we have to look at it as a prohibition. I think we have to look at it from the Second Amendment standpoint. And I get that that's a nuisance, but at the end of the day, I would not want to offend constitutional rights that this country is built on. But however, if there's something, again, I'm always open to have conversation and making amendments and that type of stuff. I'm not married to anything. I just want to make sure the intent of this bill goes through.
And the deal with the judge, he can designate an offender as a violent under this code section.
That's in code. That's current code. We just pulled that code forward.
All right, thank you, sir.
All right, good questions all around. Any others? If not, for motion?
Title sufficient to pass,
Motion
as amended.
House 50 pass committee sub. All in favor say aye. Aye. Any opposed, nay? The ayes have it. All right. Motion to rise and report. All right. Summerall FFA, y'all stay behind. So I'm meeting with y'all.